Hello and welcome to this talk about early conciliation using Acas. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. This flowchart comes from the Citizens Advice Bureau's Guide to Early Conciliation, with one addition which I'll talk about. This gives you an idea of the early conciliation process. So a prospective claimant needs to fill in online one of the early conciliation forms, or must ring Acas. Acas then will ask both parties to a potential claim if they agree to take part in conciliation. It's necessary for both parties to agree to take part in conciliation for it to take place. So suppose they do agree, the two outcomes are possible. They either agree and a settlement form, usually on a COT3, will be signed, and if the Acas officer is involved, it will be on a COT3. But if the parties fail to agree, then the Acas officer has to issue what is known as an early conciliation certificate. And that's the same outcome if at least one party doesn't agree. Now, the significance of an early conciliation certificate is shown in the next slide. A claimant may only present a claim to the Employment Tribunal if it's got an early conciliation certificate number, or unique reference number as it's known, on the claim form, which is known as the ET1. Now, the role of Acas is to facilitate conciliation up to, and in some cases including, the Employment Tribunal hearing. So it's only if the conciliation process is not successful before the hearing that the claim will reach a tribunal. What is early conciliation? Since the 6th of April 2014, it has been possible for Acas to engage in early conciliation. From May 2014, it becomes mandatory for the prospective claimant to engage with the arbitration service, Acas, in early conciliation. So the rule is that the employee must contact Acas. The employer can contact Acas. However, if the employer wants to initiate early conciliation, the way in which the system has been set up means that the employer must make contact by telephone, because no form has been provided for the employer to start the process. Basically, Acas tries to resolve the dispute before the proceedings are issued, and they do this during a prescribed period. What they're trying to achieve is a settlement between the persons who would be parties to the proceedings. It's a free process, and it's set up under the Employment Tribunals Act 1996, section 18 A1. It doesn't stop further attempts at conciliation after the prescribed period has expired. Even after that time, the conciliation officer can promote a settlement, and in the context of section 18 A, this means a settlement that avoids proceedings being instituted. But in effect, what this means is that Acas's role is seamless from the start of the proceedings with the early conciliation process right the way through to the hearing of the case itself. Early conciliation is also without prejudice to the Acas officer's general power and ability to promote an agreement, for example, getting the parties to reach an agreement and putting it on a COT3 form after proceedings have started. The rule about early conciliation essentially means that before a prospective claimant presents an application to the Employment Tribunal to institute what are called relevant proceedings relating to any matter, the prospective claimant must provide to the Arbitration Service Acas what the Act calls prescribed information in the prescribed manner about that matter. Now, the fact that the rule requires all this to be done before the claimant presents the claim to the Employment Tribunal is important, because the date of presentation of the claim is when the clock stops for the purposes of working out the time limit within which the claim should be brought. There's a list of proceedings in which Acas is allowed to conciliate. You should note that it doesn't cover all of the tribunal's jurisdiction. There's a list at the end of this presentation, and you can check to see whether your claim falls within that list. If it does, then it's relevant proceedings. Common ones, such as discrimination claims and unfair dismissal, do appear in that list, but it's important to know whether all of your claims appear in that list or not, because if some of them don't, and they are on the claim form, this has certain consequences. So the Act says that if the rule applies to a person, that person must contact Acas before instituting proceedings and may not present an application to institute those relevant proceedings without a certificate under section 18A4. Now, this is simply a certificate saying that early conciliation has been undertaken, and that will be issued, as we've seen, even when one of the parties wasn't willing to participate in the process. The rules for early conciliation are contained in a set of rules of procedures called the Early Conciliation Rules of Procedure. And these stipulate that the prospective claimant only satisfies the requirement to provide prescribed information in a prescribed manner if the prospective claimant presents a completed early conciliation form to Acas, and this can be done either online via the Acas website or by post to the address on the early conciliation form. Finally, it can be done by telephoning Acas. There is a certain amount of mandatory required content for the form, which is under the early conciliation rules, rules 2, sub-rule 2 and 3. The form must contain the prospective claimant's name and address and the prospective respondent's name and address. Acas will reject a non-compliant form, and they can either reject the form by returning the form to the prospective claimant, or they can telephone the prospective claimant to obtain the missing information. But you should note that getting the prospective respondent's name right is important for purposes that we'll look at later on. Telephoning Acas is probably the easier way of doing things. Now, suppose you're an employee. Rule 3 says that you must call the number on the early conciliation form and tell Acas your name and address and the prospective respondent's name and address. Now, as at April 2014, the telephone number to call is 0300-123-1122. When you do this, the Acas officer must insert the information you give them onto an early conciliation form. It's by far the simpler way to deal with the process if there's more than one prospective employer, or if you're not sure of the correct title for the employer. This is because the early conciliation form only has one space for a prospective respondent. So the Acas officer has to fill out one form for each of the prospective respondents. and you will get a different unique reference number or early conciliation number for each respondent. The other point to notice about telephoning is that it's the only means available if you're an employer and you want to initiate early conciliation. And this is simply because there is no form for the employer to fill out in these circumstances. If there's more than one prospective respondent, you have to complete a separate form for each. The Employment Tribunal will expect an early conciliation certificate number for each employer or person who is made a respondent to the proceedings if they're relevant proceedings. If you call Acas, you must give them the name and address of each prospective respondent for the following reasons. The wording of Rule 4 is as follows. If there's more than one prospective respondent, the prospective claimant must present a separate early conciliation form under Rule 2 in respect of each respondent, or, in the case of a telephone call made under Rule 3, must name each prospective respondent. Now, this actually isn't the original wording of the rule. However, there was an amendment to make it clear that if you're telephoning, you have to name each prospective respondent. Now, on the face of it, it doesn't appear to require you to give the address for each of them. But remember that Acas has to reject the form if it doesn't have the prospective respondent's address. So you must supply it in order that a separate form can be completed by Acas in relation to each prospective respondent. If you are represented, Acas requires you to make contact in person first, but after the first contact, the conciliation officer will deal with your representative if you wish. In the case of multiple claimants, the representative should contact Acas by telephone. The rules state that the duty of Acas is to make reasonable attempts to contact the prospective claimant. It is only if the prospective claimant consents that Acas is then to make reasonable attempts to contact the prospective respondent. If the officer is unable to contact the prospective claimant, or if they're unable to contact the prospective respondent, they must conclude that settlement is not possible. So it appears that the prospective claimant can end the attempt by refusing to give consent to the prospective respondent being contacted. So how can Acas be used? Here's their view of what they're able to do. The conciliation officer explains the process, and they may try to explain the operation of employment tribunals. They may make suggestions about what an employment tribunal takes into account when deciding a case. However, I would comment on this that you need to exercise caution over the advice that's given. Acas are not legal advisors for either side, and I think that it's advisable to be reasonably sure about what the claim is worth before approaching Acas. It may, for example, be appropriate to seek advice and to have a calculation made before talking to Acas. Now, the Citizens Advice Bureau guidance contains a link that will take you through to a calculation process which will enable you to get a rough idea of what an unfair dismissal claim would be worth in your case. The other thing that they do is to discuss the issues with employer and employee and try to reach a resolution of the issues, which may include suggesting mediation or arbitration. So you may want to keep the door open to settlement, even if the conciliation officer is not able to help to reach an agreement by suggesting the possibility of mediation. Acas says that it's giving each side an understanding of how the other side sees the case. They say that they will try to explore with each how the case might be resolved without a hearing. Now, this can be quite a difficult area because it may be possible for one side to probe the other side's case using early conciliation. And obviously, Acas acts as a conduit for proposals for settlement between the parties. So if the parties manage to reach agreement, Acas prepares a formal agreement which creates a binding settlement. However, if it doesn't, and this can happen either because there's no agreement or because one of the parties doesn't want to participate, then the Acas officer has to issue an early conciliation certificate. This must include a certificate number, and the employee, the prospective claimant, must include the certificate number, which is also known as a unique reference number, on the ET1 claim form. If the claimant doesn't include the number, the tribunal will reject the claim. A conciliation officer can promote reinstatement or re-engagement and/or an agreement on a compensation sum in unfair dismissal cases where the prospective claimant has ceased to be employed by the employer. Now note that this will include cases where the prospective claimant has been dismissed but then offered employment on alternative terms. Conciliation promoting reinstatement or re-engagement is still possible because such employees have ceased to be employed. The effect of early conciliation under Rule 6 of the Early Conciliation Rules of Procedure is that for up to 1 month from the first contact, the Acas conciliation officer must endeavour to promote a settlement between prospective claimant and respondent. First contact, which is the expression I've used, means the receipt of the form or the prospective claimant's telephone call. The conciliation officer can also extend the protected period if both prospective claimant and respondent consent, and also the conciliation officer considers that there's a reasonable prospect of achieving a settlement before the expiry of an extended period. However, the maximum extended period, which can only be done once, is 14 days. So there's a one-time only extension. If during either protected period or extended period the officer concludes that a settlement of all or part of the dispute isn't possible, then Acas is obliged to issue an early conciliation certificate. Similarly, if there's no settlement in either the prospective period or the extended period, then Acas must issue an early conciliation certificate under Rule 7.2 of the rules. The requirements of an early conciliation certificate. It must contain prospective claimant and respondents' names and addresses, the date Acas received the form or telephone call from the prospective claimant, a unique reference number given by Acas, the date of issue, which is the sending by Acas of the early conciliation certificate, and a statement of the method used to send the early conciliation certificate. Acas must send the certificate to the prospective claimant, and also if they had contact with the prospective respondent during the period, the prospective respondent. In each case, this will be done by email or post. If it's done by email, it's deemed to have been received on the same day. If it's done by post, then it's deemed to be delivered in the ordinary course of post. So what are the circumstances when you don't have to use early conciliation? Even if some of the proceedings are relevant, the employee, prospective claimant, can still institute proceedings without contacting Acas, etc., in certain prescribed cases. 1. Where someone else has complied with the Acas requirement in relation to the same dispute, and where the prospective claimant wants to institute proceedings on the same claim form. 2. The prospective claimant institutes relevant and non-relevant proceedings on the same claim form. 3. The prospective claimant shows that the employer contacted Acas over the dispute, and Acas has not received the employee's Section 18(1)(a) information in relation to that dispute. So that will be name and address. The prospective claimant must also show that the proceedings on the claim form relate to that dispute. 4. In unfair dismissal cases, if the application to institute unfair dismissal proceedings is accompanied by an application for interim relief. And then 5, there are security cases. The effect of having multiple claimants on a claim form is that the prospective claimant benefits from the effect of early conciliation on a time limit, so they may get an extension, due to someone else's contact with Acas in relation to the same dispute. How does a prospective claimant know whether their dispute is the same as another person's dispute? Well, there's no definition of dispute in the rules or Act or anywhere. Perhaps it just means the same set of facts. Perhaps it means the legal dispute between the employer and employee. How can the Employment Tribunal tell if it is the same dispute or not? Well, the system is deemed not to be an obstacle, so an informal approach should be adopted, and the same set of facts will give rise to the same dispute. The alternative, in my view, renders the early conciliation process unnecessarily obstructive.